In this immigration update, I want to look at some ways of challenging entry clearance officers' decisions by way of judicial review, because as appeal rights have been exhausted, judicial review is becoming more and more important in challenging decisions of entry clearance officers. So I want to refer you to a case that had largely passed me by. It's the Queen on the application of Mushtaq versus entry clearance officer Islamabad, Pakistan, and in brackets ECO-procedural fairness, which is 2015 UKUT 00224, and it's a decision of the President, Mr. Justice McCluskey. And the head note says this: it says the common law principles of procedural fairness apply equally to the decision-making processes of entry clearance officers. Number 2, ECO interviews serve the basic twofold purpose of enabling applications to be probed and investigated, and simultaneously giving the applicant a fair opportunity to respond to potentially adverse matters. The ensuing decision must accord with the principles of procedural fairness. And then thirdly, a breach of the caseworker guidance may render the decision of ECO unlawful. As a general rule, a challenged advance on this basis will succeed only where Wensbury irrationality or material procedural irregularity is established. So it's a really interesting case and provides some material to challenge. It was a judgment delivered by the President on the 21st of March of this year. And it was a challenge by a student who had applied for entry clearance under Tier 4 and had been refused under Rule 245ZV sub-rule K, which is the entry clearance officer must be satisfied that the applicant is a genuine student. And to establish whether he was a genuine student, the entry clearance officer interviews the applicant, and practitioners will be very familiar with this type of interview. And the President in his judgment goes through the interview, and he's very critical of the interview record and transcript. He says at paragraph 6, the transcript is quite unsatisfactory in this respect, and it's about some comments made by the entry clearance officer during the conduct of the interview. So the conclusions are from paragraph 9 and onwards, and in paragraph 9, the President finds that the common law principles of procedural fairness apply to decisions of entry clearance officers. He cites the decision of Mr. Justice Blake in T, and also his own decision in Mia, which I looked at in a previous video. And he refers back to the sort of classical statement about fairness in the House of Lords in Doody. Now in Doody we know there are 6 principles about fairness, and the 5th principle is that you must have an opportunity to make representations in advance of an adverse decision against you. And the 6th principle is that you must know the gist of the case against you. The President found that those particular principles were engaged in this case. So he said at paragraph 15, it follows from the analysis above that the decision-making process culminating in the refusal of the applicant's application was manifestly unfair. I consider that there were serial breaches of the hallowed maxim audi alterum partem. Furthermore, the decision is tainted by irrationality in the respects which I have diagnosed. The impugned decision of the ECO cannot be sustained in consequence. Now, I've looked up the Latin because I went to a comprehensive school, and it means you must listen to the other side. So the other side must be heard before they're judged. And the President finds in this case that that hasn't happened. And what he does actually in the judgment is go through each of the reasons advanced by the ECO and show either how they're irrational or that they didn't give the applicant an opportunity to address them. He also looks at the failure to follow guidance and finds in some respects, because of what he said above, they have failed to follow the guidance. Although he does establish if you're going to challenge something on the basis that Home Office guidance hasn't been followed, you need to show either Wensbury unreasonableness or a material procedural irregularity, and that's paragraph 18. Let me finish by reading his final paragraph, paragraph 19. He says, I make one concluding observation. The choice of questions and words in ECO interviews requires care and planning. Ambiguous words and phrases are to be avoided. Furthermore, fairness will often require that the interviewer invite the subject to clarify or expand an answer or probe a response. These simple mechanisms will also illuminate the court's assessment of whether any ensuing adverse decision was preordained. The nationals of impoverished and deprived countries who have invested large sums of money and whose admission to the United Kingdom is lawful if they satisfy the requirements of the relevant legal rules are deserving of no less. So very strong, helpful comments from the President at the end of this judgment. So when you're challenging entry clearance officers' decisions by way of judicial review, and when you're preparing your pre-action letters, have a look at whether they've given your client a chance to be heard, whether they've given him a chance to address the grounds of refusal before they're made, especially if it arises from an interview. Has the common law duty of fairness been satisfied? Have they followed their policy in making their decision? This is a really helpful decision which is worth looking at, and I hope this is helpful.